it'll be available, so tell your friends. The next and other item is anyone who has a question regarding the Q&A session, has a question they want to ask. Once they turn everything over, I'll be checking my email to ask the questions to preserve everybody's privacy. Because obviously we are recording and it will go up online, so it'll make the compliance folks happy. And those are the basics of it. If anybody's having trouble getting in or has a loved one that's having a little trouble getting in, make sure to send me a quick note or something, because I'll see it pop up in my email, and I'll make sure that we let folks in. I think we've got Charles has permission to let people in as well. So we'll keep monitoring lines and let everybody in. With that, we'll bounce over to a couple of housekeeping items. It's been a busy start to the year. Required minimum distributions are starting to go out for those of you that have answered calls and and sat down with us to give us the information in terms of updating. Because obviously in 2020, we didn't have RMDs that went out unless you needed them. So basics on that. We're continuing to go through our database and our document and record keeping audit. So one of us, if we need something from you, will be reaching out and just make sure that you get us what you need, or pick up the phone and respond. And we promise to make it as painless as possible. Next item on the list, we are in between quarters for rebalancing portfolios. I did a rebalance following our call last month. So for those of you with managed assets and managed accounts, you probably saw a lot of trade confirms come through. Those are available in your vault for the wealth management system, or they're available in your WealthScape account. If you need to get your password reset, or it's been a while and you don't remember what your username is and you're having a little bit of trouble getting in, make sure to send us a quick note. We can get one of us can work with you to get your password reset, get you a new link, make sure that you get in and get your access. That's really important to us. Keep in mind any of those kinds of requests where we're resetting your password or providing your username, we are going to have to give you a quick shout and voice verify for your safety and security. That's kind of a new thing. So please know we're working on it. The other thing that's also rolled out, we've been making a variety of updates to the tech stack at the office, and there's a couple of things to make sure you keep on your radar. One is we've got some website updates rolling out, an FAQ section, a number of other things. We are working with our practice management team and our website update, where Betsy Poos over here in Capitol Hill is going to give us a yoga benefit. So that is going to be available for folks to take advantage of, and we'll have a few other wonderful fun items rolling out along with that. Some better technology to take advantage of, and better ways to access your account. And we're going to have a couple of additional things regarding the email functionality with updates from our partners at FMG Suite and a couple of the other things that we use internally in the tech stack. So if you see a lot more stuff from us this year, that's because we're rolling these things out and we'll need your cooperation. Last but not least, before I introduce Brad, I want to let everybody know that because this series is new, this is the second one, second Tuesday, 5 o'clock for everybody that's on, we are going to solicit some feedback from everybody via email regarding time and format to make sure that we're hosting these calls at a good time for folks to hop on and feel good about actually being on the call, and we're not interrupting everybody's day and dinner hour. That's the basics of the housekeeping that I have. Stay tuned for more updates. We'll have more of it in March. As always, if you've got some specific related questions, make sure to send me an email, send me a quick note, and somebody from the team will make sure that we get something on the calendar so we can touch base directly. I miss not seeing everybody's faces and having everybody into the office. So that way we can sit down face to face. But we've got a vaccine coming, it's rolling out soon. And so hopefully we can start having a lot of in-person appointments, because for everybody that's been here in the office, it's a little tiny conference room and we're huddled up pretty close together. That's the gist of it. And so I've wrapped up on housekeeping. Time to introduce Brad. Ladies and gentlemen, everybody, Brad Johnson from Johnson Law Group is going to take some time and talk us through a number of estate planning essentials and various other important topics that you should do for your estate. And I will say, like, full disclaimer, Brad's worked with a number of clients. I've known Brad for probably longer than he would want me to say, because it's been a lot of years. And has done some work for myself personally and work for my firm as well as other family members. So with that, I'm going to turn it over to Brad I'm going to mute myself and give Brad the full cooperation, and I will be checking my email for questions that you all have. So Brad, you are, I think, unmuted, and I think I am.
Yes, you're muted. Well, it's a pleasure to be here. I'm happy, and thank you very much, William, for inviting me. I think, as we kind of move through life and manage the sort of the nuts and bolts of life, I like to tell my clients that there are sort of three things that really have to take care of. One is their finances, and working with somebody like William is always a good idea. Number two is taxes, and having an accountant who can help you walk through taxes, a good idea. And third is providing some sort of a legal framework for the structure of your life. And so one of the main things I always advocate is for folks to talk to their professionals, including their accountants, their financial planners, and their lawyers about their lives. I'm, as William said, I'm the principal of Johnson Law Group, which is a small law firm which is located on Capitol Hill in DC, and has been working out of working off the hill or on the hill for 30 or so years now. We have four lawyers, and a large part of our practice is working with folks on estate planning, and then on the other side, estate administration. So I think the question is, why, what's important about estate administration, about estate planning, and why is it something that you should be thinking about? Well, first of all, there are a number of reasons for it. One is a very common sense, reason, and I think is probably the foremost reason, is that, unfortunately, we all die, and fortunately, many of us have assets that need to be passed on to, beneficiaries or future generations, and to do that, to effect that transfer in an orderly way, you have to engage in some estate planning. As I like to say, if you don't write a will or have a trust or have some sort of testamentary document, in your quiver, the local jurisdiction, whether it be Maryland or Virginia or the District of Columbia, they'll be able to administer your estate for you, and that's not necessarily something you want to do, because without effective estate planning, you can your family, and the people who you leave behind can be saddled with some complicated issues that, number one, are expensive, and number two, more important, I think in many cases, it takes a lot of time and energy and effort to resolve issues that easily could have been resolved prior to your passing away. Lots of people think that estate planning is complicated. It's really not. My experience in doing this for a long time is that folks will say at the end of the process, well, if I'd known it was going to be like this, so this has gone so smoothly, I would have done it a long time ago. So the hardest part is actually coming to the table and making that phone call, to a lawyer, and say, hey, can we do a consultation about estate planning. In addition to avoiding sort of complicated, sort of court proceedings after you die, if you don't, plan in advance, there are other reasons to, um, to engage in estate planning. Clearly, as I said, the estate planning reduces, your over time sort of legal costs to your estate. Um, Estate planning can protect beneficiaries, whether they are, children with special needs, or parents who are are say have Alzheimer's, or otherwise becoming incapacitated as they age. Um, um, and clearly that you want to be able to protect um, assets, from unforeseen events. Like, again, if you become incapacitated, what does that mean for the assets that you might have, and how can you protect those assets? Um, an example of this, you know, if in terms of estate planning, if you're faced with the possibility of needing long-term, assistance from the government for long-term care, if for whatever reason you may have disposed of your family homestead, that could put your assets at great risk, and being subject to being sort of taken, by the government, for your care. It's just an example of that. And then finally, although it's hard fully to avoid the tax man. There are ways through the setting up of revocable and irrevocable trusts to if not avoid taxes, at least reduce the impact of taxes on your estate, and there's obviously a benefit to that. So those are some of the reasons for sort of engaging in estate planning. So I guess the next question then is, what does an estate plan, quote unquote, consist of? Well, essentially, it's comprised of three main things, sort of a three-legged stool, so to speak. First, is and most important is a testamentary document. And by testamentary document, I just mean, like a will, or in the alternative, to a will, a revocable trust. And what I'll do is, I'll circle back to this in a few minutes to kind of talk about the distinction and the advantages and disadvantages of a revocable trust as opposed to a standard will. So that's the first piece of the puzzle, is your testamentary document. The second one would be a power of attorney for asset management. And a power of attorney, as we call it, a durable power of attorney for asset management. And the purpose of this kind of power of attorney is to name somebody, and perhaps an alternate if you have one, to be able to make financial decisions on your behalf if you become incapacitated. So if you need to pay the utility, or if you need to pay a mortgage, or you have some other financial transaction, you convey real estate with a power of attorney, you're basically giving someone the permission to act in your behalf when you can't do it. And the power of attorney would be sort of based on a finding of incapacity, by your doctor, or it can be sort of just granted outright to someone who you trust to make financial decisions if you can't do it. Now, the important thing to remember about a power of attorney is it's only effective and only can be used while you're alive. If you die, the power of attorney becomes, is no longer valid, and your testamentary instrument will take over with respect to your, how your assets are managed. So that's the second one. So the first one was a testamentary document. The second one was the power of attorney for, for finances and for asset management. The third leg of the stool is another power of attorney, but it's for healthcare. And this is, again, if you become incapacitated, not if you die, but if you become incapacitated and say you're in the hospital and you can't make your decisions on your own about how to, how to, your medical team will work with you. You name an agent, and again, and perhaps an alternate to help make those decisions. So the question then becomes, okay, well, you have someone going to try to talk to the doctor about which path to take to that is most likely to lead to my recovery. And that can be a very, as many of you probably know through your own experiences with friends or family members who have fallen ill, that can be a very complicated undertaking. And so the power of attorney for healthcare not only names someone to be your agent to make decisions on your behalf, but also it usually sets out a set of directives. In other words, the so how you would want your agent to make a decision about your health care. Some people you would want their doctor to do everything that's possible to keep them alive. Other people at the other end of the spectrum say, look, just if this isn't going to end well, just keep me comfortable and let's leave it at that. So the directives in a healthcare power of attorney can run the spectrum of sensibilities. And when we work with clients to develop these kinds of documents, we have a fairly forthright conversation about, okay, you're sick. How do you want your medical team to work with you? So that's the third document. As I said earlier, I wanted to circle back. William, I see that there was a question. What was that question? Did you want to answer that now, or do you want to wait until the end, or how do you want to do that? William, you're muted.
Doesn't like to unmute sometimes. On my end, yeah, you can go ahead and answer that now if you've got a question that's come through to you. I'm going to check my email here to see if I had anything pop up.
So I see the question is, can you talk about digital executor or digital custodian? I'm not exactly sure I understand the question. Are you talking about an agent who is dealing with your digital assets?
That's right. So someone to take responsibility for your digital assets and your digital accounts, should you lack capacity to handle that yourself.
Yeah, basically, yeah, that's a really good question. As far as your digital assets, the best practice right now is for when you name your agent, whether it's in your testamentary document or your powers of attorney, which would be used while you're incapacitated, would be to provide the agent with the power to manipulate and to access your digital assets. Obviously, the one of the big issues there is to make sure that you list in these documents or make available to your agents the the assets to which you're referring to which you're referring, and also the authentication protocols that would be required for your agent to access them. Does that answer the question?
Yeah, that's fine. Thank you.
Yeah, sure. Okay, so I just want to circle back quickly to the testament design, because lots of people, lots of folks, when they come in, they say, "Oh, I don't know, everybody, my parents always had wills, and and I hear this, all this, I read all this stuff about trusts, and what's the difference between a will and a trust?" And there are several, and there are advantages and disadvantages to each. And each family or each person really kind of needs to look at, what their testamentary intent is, what their testamentary goals are, before decide, in trying to decide whether a will or a trust is the right mechanism for them to transfer their assets, from themselves to their beneficiaries. Essentially, a will, as you probably know from Perry Mason and lawyer shows on TV, it's pretty straightforward. I mean, someone is named as your executor, or in the district, it's called, and actually in many jurisdictions, it's called a personal representative. But you name someone to be your executor, and then perhaps with an alternate. And that executor's job, when you die, is to locate your assets, identify your assets, gather them together, and file something called a petition for probate in the local court, and then together with your death certificate. And then what the court does is appoint, your executor will file the paperwork, often with the help of an attorney, but they can file the paperwork, and then in a relatively short amount of time, the court will review the will, and then certify the person as the official personal representative or executor of the estate. And then that in the district, they issue something called the letters of administration. And the letters of administration provide the personal representative or the executor with the power to go down to Citibank or wherever and withdraw the funds in the deceased's estate, and set up an estate account. And otherwise to sell the cars, or sell the house, or what have you, depending on what kind of asset it is. Liquidate the brokerage accounts, and then the personal representative's or executor's responsibility is to distribute the assets according to the wishes, as expressed in the will. And the way this is done, at least in the district, is usually it's an unsupervised estate, and the personal representative just takes the responsibility for, again, gathering the assets and distributing them. There are some requirements that go along with this, including publicizing or publishing the event of your death in the newspaper, and giving creditors 6 months to come forward with any claims against the estate. So typically, even a simple probate proceeding or an estate proceeding in court, at least in the district, is usually six to 9 months, sometimes a year. If there are any complications, it can extend much longer. In other jurisdictions, handle it a little differently. If you went to my website or anything, you'll see that we practice law also in the state of Vermont, where I'm sitting right now. And in Vermont, it's the state proceeding is much more onerous, where every single step taken by the executor is supervised by the court. and every sort of just any distribution of any asset needs to get explicit court permission. So the long and the short of it is that if you die with a will, you are subject to a court proceeding. Sometimes it can be fairly straightforward. Sometimes it's not. The alternative to your having a will as your testamentary document is to have something called a revocable trust. And a revocable trust essentially does the same thing, except it is a private document. And essentially, the way it works is that you set up, you create a trust and you place your assets into the trust. And then instead of naming an executor, you name somebody called a successor trustee who takes control of your assets after you die and then just distributes them by operation of law without any court involvement. So it's a much simpler process, and it does not subject you to the sort of the whims of a court bureaucracy. It's especially important for people who own real property, houses or land in different jurisdictions, to very carefully consider, whether they should have a trust. Because if you have real property in more than one jurisdiction, that means that you're going to have probate or court proceedings in more than one jurisdiction, and just the time, complexity, and cost just mounts. The downside of a trust is that some people.
Pretty straightforward here.
Excuse me? I'm sorry. The downside of a trust is that it's a little bit more expensive to set up, because typically folks' most important asset is their home. And in order to place your home into a trust, you have to basically retitle the property, so that instead of a house being in the name of John and Jane Smith, it has to be in the land records, it has to say that it's in the name of the John and Jane Smith Revocable Trust. And so there's some costs associated with that, and then costs associated sometimes with moving other assets into the trust, so that you are in a situation where all of your assets are controlled by the trust or by beneficiary, or the naming of beneficiary of an asset. And some people don't like trusts because it's just more complicated, frankly. Because once you draft your will, you kind of you draft it, you sign it, stick it in the drawer, and then don't worry about it until you die. With a trust, every time you make a significant asset, you kind of have to ask the question: does this need to go into my trust? Is my trust involved in this? Should my trust be involved in this asset? Big picture, I think the overall cost of estate administration with trusts to the estate, the overall cost from beginning to end, is probably lower than with a will, but the upfront costs are more. You have a will is relatively inexpensive to draft and execute, but then you have the potential for pretty extensive court and attorney and other costs during the probate process. With a revocable trust, you have some upfront costs, having to redeed property and that sort of thing. But on the back end, you have fewer costs and less complexity. So that's sort of the three areas of the three parts of the estate plan that we recommend. There are lots of sort of nuances, lots of little things that we would discuss, or that you would discuss, with your attorney in terms of the specifics that are found in these documents. But that's sort of, again, broad brush. Those are the three main documents that you need to be concerned about. So with that, I mean, that pretty much covers the waterfront. I'd like to give you a chance to ask any specific questions that you might have about this, or if I could sort of expand on anything that I've said, or if I've said something that's confusing, give me an opportunity to clarify.
Thank you very much, Brad. We've actually got a couple of questions that have come in. So I'll give them to you kind of one at a time, and then you can, I'll give you one and you can respond to one, and then I'll move to the next one.
Sounds good.
So first one is in regard to, you mentioned wills and trusts. So for somebody with a basic estate that doesn't have an estate taxation problem, it's not terribly diversified, is a will sufficient, or do they need a trust as well? And if someone needs a trust, when should they really consider establishing it? If somebody young like me, should I have trust? Should I wait till I'm significantly older and my estate is much larger? And then on my note, what are the types of things that you feel should be in a trust, or are there things that just simply shouldn't be in a trust?
Yeah, I mean, basically, a good question. I think that, and this is what I tell my clients. I said, look, if you, I mean, you have different clients come in. We talk to different clients, but if you have like a sort of like I'm not sure how to describe this, but sort of like a standard estate. I mean, you have a wife, a couple of kids, a dog and a cat, a house in one jurisdiction, and a car. Okay. And that's basically, and maybe a brokerage account, checking, savings, some life insurance, and a retirement account. That is a typical profile of someone who will come in. And when they come in, I'll say, look, if with that profile, you have a choice. You can do do a will, because we're just talking about one probate proceeding, one court proceeding if you die, and it should be fairly straightforward. All right. But you can also do a trust too, if you contemplate down the road, getting a country home in a different jurisdiction, for example, or investing in a house or land or commercial property someplace else in a different jurisdiction. But if it's that kind of a profile, either one is totally fine. The reasons for having a revocable trust, on the other hand, are, number one is, there are people who come to me, I just don't want the District of Columbia or the state of Vermont or the Commonwealth of Virginia involved in my affairs. That's his sole reason to set up a trust, because if they set up a trust, the state will not be involved in their affairs. So that's one reason. The second reason is if there is a lot of discord in the family, and the reason for that is because when you establish a trust, when you establish a will, and then you die, and your will goes into court, it's a matter of public record. So anybody who wants to object and make trouble, it's very easy and very inexpensive for them to go down to the courthouse and say, I object, and raise all sorts of problems and costs and delays. So if a family has a situation where they just, and this comes up, I get it all the time. They just said, I just know that, cousin Joey, he's going to cause trouble because he just never got over the fact that my father did X or Y or Z to him 27 years ago. So if that's the case, you move your testamentary documents into trusts, or you head in the direction of a trust. And that is because a trust is a private document. It doesn't mean it can't be challenged, but it can be challenged, but it requires the person who is challenging it to hire a lawyer, go down to court, pay all the fees, and start their claim. And so that's a real burden. So you're somewhat protected. Certainly, as I mentioned before, if you have real property in more than one jurisdiction, you definitely should have a trust. It just doesn't. It's even from a simple financial standpoint. A trust makes sense. Otherwise, the cost just becomes prohibitive. The other reason for doing trusts is for high wealth individuals. There are there are trusts called, like, such as an AB trust, where you can where couples can shift assets so in order to minimize taxes. You can build in AB trusts into it as a testamentary trust into wills, but it's pretty complicated, and I don't recommend that. The thing, yeah. What else am I going to say about that? So those are the main reasons, for trusts. The other part of the question is about what do you put into a trust. Essentially, if you do set up a trust, your overriding goal or your task is to make sure that if you die, none of your assets are held solely in your name. So when you set up a trust, all of your assets either have to designate the trust as a beneficiary, be an actual asset of the trust, such as a house or a car or something, or name other individuals as beneficiaries of the asset. You don't want to die with, I had a case not too long ago, a young couple, they came in, we set up a revocable trust, and we were going through we kind of scope out all of the assets. And one of the assets was they had a relatively new, nice car, which happened to be only in the husband's name. And, we sat at my conference table in the office before COVID, and I said, you need to the husband, you need to, at the very least, put that car into your wife's name, or better, put it in the name of the trust. You just go down, DMV and do that. Well, long and short, he never did that. 3 months later, he was diagnosed with brain cancer, and he was dead, in a month after that. So they had all of their assets except for this stupid car was in the trust, and they passed easily to his wife and to his other beneficiaries, but the car was left out there hanging, and we had to go down to court and file papers to get access to the car. So to answer your question, when you have a trust, you make arrangements to make sure that you have nothing left in your name when you die.
Okay, so that's easy. So everything from the pearls to the multi-million-dollar investment account.
Exactly.
So two questions. Also, first, creditors and predators having trusts, revocable, irrevocable. Does it make a difference in terms of what kind of protections I get in terms of complexity and my estate against getting sued, default, etc., any of those kinds of things?
Yeah, we didn't really get into the distinction between revocable and irrevocable trusts, but as a general matter, revocable trusts don't protect you from creditors or taxes, really. You can structure, you like I was talking about the AB trusts. That's a revocable trust. It reduces taxes, but it doesn't necessarily protect you from tax. It's not like a tax shelter or anything. And certainly trusts do not protect you from creditors or revocable trusts. Irrevocable trusts, on the other hand, and these can take various forms. They can be sort of special needs trusts, or just irrevocable trust, trust funds for beneficiaries, and what these are ways to, in some people, this is less of a problem these days, but in the past have wanted to reduce the size of their estate, and they put money into irrevocable trusts. And when, and again, the operative word is irrevocable. Once you put money into an irrevocable trust, the money isn't yours anymore. It belongs to somebody else. So therefore, it is protected from creditors and taxes, for that matter.
Well, the trade-off is then the crunched accelerated tax rate.
Exactly.
That's next month's topic. That's taxes.
Right.
It's not this month's topic. All right, so that sounds pretty good. Another question. So trusts, minors, conservatorship. So if I've got minors in my life and I want to make sure they're taken care of, God forbid something happens to me, I need to come see you. What are the things I need to have in hand in order to come see you and make sure that all my stuff is in good order? And let's say I've got some of that stuff that I did a long time ago when the kids were born, but now the kids are older and it's 10 years old and I don't know what to do. Or I did it a long time ago and now the kids are, now they're adult children.
Right.
What do I collect? What do I do when I come darken your door?
Right. Well, I mean, basically, it's pretty straightforward. I mean, the thing is if you still have minor children, we make sure that either the will, or the trust, in either case, that the minor children are looked after, both in terms of in terms of money, but also in terms of life, and how where they live and all that sort of thing. And then once the child has attained the age of majority, assuming that you want your assets to go to someone who's 18 or over, then it's pretty straightforward. You devise your assets in that way. Through a trust, through a sort of trust instrument, you can say, well, we do have these assets. I think that the trust assets ought to be used until the child is 25, for education and maintenance. And then after 25, he or she can do whatever he wants. And so we would set something like that up. In terms of what to bring to the office or bring to the table when we're setting this up, the main thing is to know, is to have a sense of what you want, how you want to distribute your assets, who you want to distribute them to, and for what purpose. Those are the most difficult issues. And then sort of as administrative point, we folks bring in a list of assets with account numbers and that sort of stuff, so we can identify them. But that's just an administrative task.
Fantastic.
And typically the way our process works, and I can't speak for other law firms, but the way our process works is that we do and sort of a big picture overview initial consultation, which we don't charge for, and we talk about a lot of the things we've been talking about today, sort of big picture issues. Once that happens, we have a questionnaire that goes out, which asks a whole bunch of questions about the specifics of their estate, what they have in their estate, and what they want to do with it. And then and once we get that questionnaire back, and the questionnaire can be, we send out a written questionnaire, it can be done in writing, or they can call us up and we can do it over the phone, or have a meeting, pre and post COVID. And then we draft the documents, and the documents are distributed to everybody, and everybody looks at them and kind of go back and forth and until we get the language right and make sure there are no typos. and and we arrange a time to have them executed. Pretty straightforward.
Fantastic. We've got just a couple last little questions. One of which I'm going to go ahead and throw out there because I'm sure it applies to a lot of us here. And one is charity. I want to leave money left over to charity, but I don't know what charity.
Mm-hmm.
Do I have options? Are there things like, is that something I name in a will? Like, how do I go about identifying something along those lines? Like, is that something you and I have a conversation about, or is that something that, is there some kind of vehicle where I can name someone to sort of execute my wishes in the future, but, we can at least identify where that asset goes in case I do get brain cancer or I get hit by a bus. I mean, it's dicey bicycling in DC.
Yeah. Yeah, I think there are two answers to that question. First is most people come in, they have a history of giving, and so that we specify in the trust or the will that I want X amount of dollars or X percentage of my estate to go to these charities, and we list them. Okay, that's one way to do it. Other people come in and say, well, I don't really have any. I mean, these are my interests. I'm really interested in, water quality. Okay. And so what we can do is set up a charitable trust, which would be administered by a trustee, someone who understands your sensibilities, and and say this money is to be used for efforts to improve water quality. And so the charitable trust can be a short term, or it can be fully funded and live on in perpetuity, for that matter, depending on the size of the assets. But people will come in and say, "Here, I have $100,000, and I don't know how I want to spend it, but I want a trust. I want it to be for improving water quality in the DC area," or something like that.
Okay. And we've got kind of one last question that popped up in the feed. And this one's actually, I think, pretty straightforward. And I'll give it to you kind of in two versions. One is, I've got family all over the place, and I want to leave everybody money. Do I have to file my will everywhere where those people live, or do I just file in like my state where I have my assets?
And you don't have to file your will.
Oh, fabulous. All right. Then the other side of the thing is, when I move at some point in time and I'm domiciled somewhere else, what kind do I have to make any updates to my estate planning documents? If I'm here in DC, but it's cold and I'm old and I decide to re-domicile down somewhere, more tropical.
Right.
Do I have to do anything? What if I decide to go full expat in retirement, and you'll find me on an island beach somewhere? Do I have to do anything special?
If it's in the United States and in probably in most predictable countries like in Europe, Australia, New Zealand, that sort of thing, you're as long as your will was validly executed in the jurisdiction where you lived at the time when you signed it, full faith and credit will be extended to that document. And so if you live in DC and you retire in Arizona and you have a DC will, when you die, Arizona will just do what the DC will says. Now, having said that, and so when people move, and people move all the time out of DC, as you know, when people do move, what I tell them is, say, look, if you're moving to Minnesota or whatever, there's no rush for you to change your will, get a Minnesota lawyer, and have a Minnesota will. However, when it comes time to amend your will, you want to change it and make changes or whatever, that's when you just create a Minnesota will. Okay. If it's minor, I wouldn't worry about it. If you move to someplace like Sri Lanka, on the other hand, you should get a Sri Lankan lawyer and you should establish a Sri Lankan will.
Okay, but for the most part, Western Hemisphere, I'm probably all right. You know, most of the developed world. So the south of France, you know, Monaco, the Costa Ricas, the, you know, if I, you know, San Martin, you know, all the usual spots.
That's right.
Okay, good. Fantastic.
Great.
All right. Well, that brings us through kind of our Q&A period. I don't see anything new in the chat. I'm going to refresh the email again and make sure that we've got everybody's questions answered. In the event you think of something afterward, and feel welcome to email me. I'll make sure that I pass it along to Brad, or you can reach out to him directly, set up an appointment. We will, following the call, post the usual like YouTube items, along with making sure that you guys get an email. It's got Brad's contact information. There's a handout that goes
Yeah, we
along.
have a handout. Yeah, just I have that handout if you want to send that around.
That would really go
And
out.
I'm more than willing to, if anyone wants to give me a call. Everything we do these days is electronic, so we can do everything by video calls and even sign documents electronically now, virtually. So
Perfect. Great news. Well,
okay.
with that, I bid everybody a fantastic evening. Thank you for everybody who hopped on, and please join us again next month. We look forward to seeing you. Keep an eye out for the emails, and obviously feedback is always welcome. So with that, look forward to seeing everybody soon. Stay safe, be well, wear a mask, and wash your hands. All right. Have a great one.
Everybody,
Thanks,
Bye-bye.
William.
it's been a pleasure.
Thank you, Brad.
Yep, thank you.